Bill 279, which is an act relating to the Uniform Trust Decanting Act. House Bill 350, which is an act relating to the Uniform Directed Trust Act. And finally, House Bill 614, which is an act relating to land improvement fraud and timber trespass. Members, we have received requests to read two House concurrent resolutions adopted pursuant to the consent calendar. The first is HCR 161, which is the House concurrent resolution honoring Newport City Councilor Chair John Wilson for his national and municipal public service. Please listen to the reading of the resolution.
Whereas John Wilson was born and raised in Rock Island, Quebec, and he and his wife, Janice Wilson, emigrated to Vermont as young adults. And whereas in 1968, the U.S. Army drafted John Wilson, and although he could have surrendered his green card and returned to Canada, his patriotic desire to become an American citizen led him to serve his new country. And whereas after completion of basic training, John Wilson was deployed to Vietnam, where he encountered combat. And whereas in 1983, during his military service, John Wilson was proud to take the oath as a U.S. citizen. And whereas John Wilson's Vietnam service began a 28-year U.S. Army career that took him and his family around the world, and in 1998, he was honorably discharged from military service as an operations sergeant major. And whereas in 2001, John Wilson won a seat on the Newport City Council, on which he served until 2018, and then again from 2020 until 2024. And whereas John Wilson's municipal legislative colleagues respected his life experience, and for 15 years he chaired the Newport City Council. And whereas in 2018, the Northland Journal recognized John and Janice Wilson, honoring their role in advising U.S. military veterans. And whereas after over 2 decades of leadership and conscientious work as a member of the Newport City Council, John Wilson has decided not to stand for re-election in 2024. Now, therefore, be it resolved by the Senate and House of Representatives that the General Assembly honors Newport City Council Chair John Wilson for his national and municipal public service. And be it further resolved that the Secretary of State be directed to send a copy of this resolution to John Wilson and to the Newport City Clerk.
Next is HCR 163, which is a House concurrent resolution recognizing Public Schools Week in Vermont. Please listen to the reading of the resolution.
Whereas since the establishment of the state of Vermont, public schools have served as a foundational community and cultural institution. And whereas public schools facilitate a gathering of students from diverse demographic and socioeconomic backgrounds into a forum where they can both learn about and better understand the lives of their peers. And whereas the high quality education that public school teachers present to their pupils reflects both specific subject knowledge and a broad perspective on our state, nation, and the world. And whereas public schools are of enormous importance to all residents, as they are a major formulator of Vermont's future, and whereas they are a vital employer of Vermonters who are teachers, coaches, administrators, nurses, cafeteria staff, and custodians, and whereas school board members who are volunteers or at most receive token compensation play a critical role in the governance of our public schools, ensuring citizen input into the public education. And whereas the sports, dramatics, and other activities held under the auspices of public school systems enable the broader community to enjoy watching and participating in these events. And whereas across the nation, the week of February 26th to March 1st is being celebrated as Public Schools Week. Now, therefore, be it resolved by the Senate and House of Representatives that the General Assembly recognizes the week of February 26th to March 1st as Public Schools Week in Vermont. And be it further resolved that the Secretary of State be directed to send a copy of this resolution to the Vermont Secretary of Education, the Vermont State PTA, the Vermont School Boards Association, the Vermont Superintendents Association, the Vermont Principals Association, and the Vermont NEA.
Are there any announcements? Member from Winooski.
Madam Speaker, it's one of my favorite days here in the State House where I actually got to bring my sister to work day. Here with me is Mackenzie Smith, a junior over at Colchester High School, an avid and outspoken advocate on equity and justice. And today, really just wanting to flex her new AP US government knowledge as she shadows me through our work. So I hope the chamber will join me in welcoming my sister to the People's House.
Will the family of the member from Winooski please rise and be recognized? Member from Essex.
Madam Speaker, I am also lucky to have a very special visitor today. My daughter's best friend, Ro Doherty Maze, thinks our work at the State House is cool enough for them to spend a day of their school break shadowing me and learning about policymaking. Without my daughter, by the way. Ro is in 9th grade at the Vermont Commons School. In addition to being one of my favorite people, Ro is a social justice advocate, a talented volleyball player, and a lover of all things K-pop. Please help me welcome Ro Doherty Maze to the People's House.
Will the guest of the member from Essex please rise and be recognized? Member from Vergennes.
Thank you, Madam Speaker. I move that the Committee on Appropriations be relieved of House Bill 645, which is an act relating to the expansion of approaches to restorative justice, and that the same be committed to the Committee on Ways and Means.
The member from Vergennes moves that the Committee on Appropriations be relieved of House Bill 645, which is an act relating to the expansion of approaches to restorative justice, and that the same be committed to the Committee on Ways and Means. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have relieved the Committee on Appropriations of House Bill 645 and committed the same to the Committee on Ways and Means. Member from Burlington.
Madam Speaker, we just heard a resolution acknowledging this week as Public Schools Week, and I'm happy to be wearing red for Ed. Public Schools Week is an annual week-long celebration dedicated to the invaluable contributions and achievements of educators and education advocates in our public schools and the communities they serve. It really is a beacon of recognition for the unwavering dedication and resilience of our educators and school communities. You heard a lot of unsung heroes mentioned in that resolution: school bus drivers, school nurses, cafeteria workers, school board members, teachers, custodial staff, coaches. They all work together in our public schools, the great equalizer for children, to help set young adults on the path to a fulfilling life. In today's polarized environment, public schools play a more important role than ever in promoting unity and serve as a bedrock of democracy. The people mentioned don't often get the thanks they deserve, so let us please do so today by welcoming members of the State Board of Education, Agency of Education, Vermont Principals Association, Vermont School Boards Association, Vermont Superintendents Association, and the Vermont National Education Association, as well as teachers and school board members who are with us today in the gallery. Let's take a moment to spotlight the remarkable efforts these folks have had in shaping our kids' futures and the future of our community by welcoming to the People's House.
Will the guests of the member from Burlington please rise and be recognized? Are there any further announcements? Member from Wolcott.
Thank you, Madam Speaker. The Older Vermonters Caucus will meet tomorrow in room 270 in the pavilion. And for the first time, we're going to be serving lunch. So come on over. Thank you.
Are there any further announcements? Member from Derby.
Did you say me, Madam Speaker?
I sure did.
Okay, I didn't hear you. I'm sorry. Madam Speaker, I spoke with my dad yesterday, and he wants to extend his sincere thanks to everybody in this General Assembly. It made his 96th birthday the best one he's ever had. And he said you come in a close second to the Mormon Tabernacle Choir and whoever they are. But anyway, thank you from me as well. You really did it up, and it's going to be a video that I'm going to keep for the rest of my life, and my father will too. Thank you all.
Yeah. Are there any further announcements? Member from Hartford.
Madam Speaker, I would ask you and the body and the member from Essex to forgive me for not performing the devotional today. My voice is my instrument, and the instrument was not up to par. Thank you.
Feel better, member. Are there any further announcements? Seeing none. Orders of the day. Members, we will begin with House Bill 780, which is an act relating to judicial nominations and appointments. The bill was referred to the Committee on Judiciary, which recommends that the bill be amended as printed in today's calendar. The member from Burlington, Representative Rachelson, will speak for the committee. And then carrying an appropriation, the bill was then referred to the Committee on Appropriations, which recommends that the bill ought to pass when amended, as recommended by the Committee on Judiciary. The member from Underhill, Representative Squirrel, will speak for that committee. Please listen to the second reading of the bill.
H 780, an act relating to judicial nominations and appointments.
Member from Burlington.
Thank you, Madam Speaker. Judges play an important role in our society by upholding the law and ensuring justice is served. Just trying to get the mic right here. It is believed that the center of any system of justice is the judge. A good judge has the ability to apply the law to the facts and to understand how a judicial decision will affect the people appearing before the court. It is the ability to communicate with counsel, jurors, witnesses, and parties calmly and courteously, as well as the willingness to listen to and consider what is said on all sides. And frequently, as our chief administrative judge has said, on people's worst day ever. Appointing judges is an extremely important job. In the Fordham Urban Law article, How Pickers Pick, Finding a Set of Best Practices for Judicial Nominating Commissions, the author argues that there is a continuing need to reevaluate and assess methods of judicial selection to ensure a qualified bench and advance the cause of justice. The author claims that states still should build upon and improve the judicial selection methods in order to be responsive to the needs of society. She says we should borrow and profit from the past and meet the needs of the present. Vermont utilizes what is referred to as the Missouri Plan for Judicial Selection. In 1940, Missouri became the first state to adopt a merit selection system. Since its adoption, the merit selection system has become increasingly common and is now the system used in 21 states, including us, and in the District of Columbia. The Missouri Plan is commonly referred to as a merit selection or an assisted appointment process. What is the process? I didn't know until I served on and continue to serve on the Judicial Nominating Committee. A nominating commission reviews the qualifications of judicial candidates and submits a list of names to the governor, who appoints a judge from the list, who is then confirmed by the Senate. Judicial nominating commissions work to encourage highly qualified applicants to apply and to screen and interview eligible applicants in order to provide the governor with a pool of highly qualified candidates. Vermont's Judicial Nominating Board, or the JMB, as it's affectionately called, follows the Judicial Nominating Board rules, which work something like this. When a judicial vacancy or opening occurs, the board receives notice of vacancy from the governor. The chair of the Judicial Nominating Board then sends a request to the Vermont Supreme Court to send out the appropriate notice of judicial vacancy to all members of the Vermont State Bar by electronic mail. Did you know that the JMB screens applicants for several positions? Supreme Court Justice, Superior Court Justice, Magistrate, and the chair of the Public Utility Commission. I've had the great honor of serving and continuing to serve on the JMB since 2021, along with two of my esteemed colleagues in the House. Board members may actively encourage individuals to apply for judicial office. If an individual so encouraged by a board member applies, the board member shall report this communication to the board chair. The board member's ability to participate in the candidate's interview, in the discussion of the applicant's candidacy, and in the vote on the applicant's candidacy is determined pursuant to the board's conflict of interest policy. And I'm proud to say Vermont is only one of a dozen states that has a conflict of interest policy for its nominating commission. So H780 proposes 5 modifications to the procedures for making judicial nominations and appointments. So first, you might ask, why are these changes being proposed? While Vermont's system is quite good, it is not perfect. This bill addresses specific issues that have been identified and looks at the best practices, recommendations, and research from many national organizations. So, what are the issues that have been identified? The first issue is we must attract a more diverse, qualified applicant pool with the goal of having a qualified and more diverse judicial bench. In 2020, our Chief Justice attended the National Chief Justice Conference and was part of passing a resolution aimed at combating racial prejudice in the justice system, and specifically looking at what systemic changes are required under the law to address this prejudice. Madam Speaker, may I quote from the Vermont Chief Justice's 2022 press release?
You may.
Thank you. The Vermont Chief Justice stated, "The Vermont Constitution entrusts the Vermont judiciary with the responsibility to protect the rights of all Vermonters and visitors to our great state through access to the courts and equal justice under law. Specifically, the Constitution requires that every person within the state ought to find a certain remedy by having recourse to the laws, and that justice must be impartially administered without corruption or unnecessary delay to all Vermonters. With these constitutional requirements in mind, the judiciary continually strives to identify, evaluate, and address bias, racism, and prejudice of any kind within the justice system." In 2021, a study by the Council of State Governments found that in Vermont in 2019, Black people were over 3 times more likely to be defendants in a misdemeanor case, and almost 6 times more likely to be defendants in a felony case than white people. This was true even though 94% of the total number of defendants were white people. The study found that this disparity was particularly stark for felony drug cases, where Black people were over 14 times more likely to be defendants than white people. Moreover, Black people were over 6 times more likely to be incarcerated in Vermont than white people. The judiciary has taken these findings very seriously, establishing a commission on diversity, equity, and inclusion, closed quote. We heard from the Vermont Chief Justice and the 2 additional Vermont Supreme Court justices recently who serve on this new judicial commission. The commission held 15 public forums around the state. They did 1 in each county and 2 in Chittenden County. One major theme the justices heard was the complaint of the lack of diversity among court officials and employees. The 2021 report of the Racial Equity Task Force to the governor included the recommendation to build a more inclusive judiciary. That recommendation stated that a judiciary that reflects the people not only builds public trust and confidence, but it also ensures impartiality on both an individual and structural level. A homogeneous judiciary results in disparate treatment of people of color. The report suggested legislation to ease residency, years of practice, and trial-focused experience requirements for attorneys seeking a seat on the bench. Additionally, a 2014 study conducted by the American Constitution Society for Law and Policy found disproportionate representation of racial minorities and women serving on state courts. This was the first time that researchers had gathered data on the demographics of state court judges in all 50 states. Unfortunately, they found troubling differences between the race and gender composition of the courts and the communities they serve. The study calls the disparity the gavel gap. Each state got a report card. Madam Speaker, Vermont received an F and came in 41st for combined gender and race ethnicity representativeness rank of state courts. The data was compared for the number of judges of color and women judges as percentages of all judges in our state. This data was compared to women and people of color as percentages of the state population. So in 2014, 23% of our court judges were women or other minorities, as compared to 54% of Vermont's population comprised of women or minorities. You might think there just aren't more women or people of color to apply. Yet this study found that women comprise roughly 1/2 of the US population and 1/2 of American law students, and has been the case for the past 20 years. But less than 1/3 of state judges are women. The findings from the study should inform states that the current method of identifying and selecting judges isn't working as well as it should. We need a better process for developing a pipeline of women and minorities to serve as judges. The report went on to emphasize that our courts must be representative in order to fulfill their purposes. This data was from 2014, and we have improved since then with our first judge of color and more women judge appointees. As of today, we currently have 15 women judges out of 37, which puts us at 41%. But let's be clear, we are still not anywhere close to where we should be. And as for what the best practices and recommendations say, the Quality Judges Initiative Project has something that they called the O'Connor Judicial Selection Plan. That plan was developed by the late U.S. Supreme Court Justice Sandra Day O'Connor. And the recommendations that came out of that report listed respect for demographics, social makeup of community. The overall makeup of the court must reflect respect for the community it serves. Those responsible for selecting judges should be mindful of this. This does not mean that race, gender, or ethnicity of judges must be perfectly proportionate to the demographics of the community, although such factors might be among those considered. It does mean, however, that every judge in the courthouse should be cognizant of the community that he or she serves. Nominating commissions, they recommended, should be balanced politically, ideologically, and demographically. Race, ethnicity, gender, and geographical diversity among commission members should be encouraged, if not required. The Brennan Center's publication, Building a Diverse Bench, a guide for judicial nominating commissioners, makes clear that empirical research shows that the greater the rates at which females and minority applicants apply for judicial seats, the more likely they are to be selected. It's kind of obvious, but important. Achieving a diverse bench requires that these candidates not only consider a judicial career, but actually apply. Nationally and in Vermont, there is often a lack of diversity in commission membership. For a nominating system to be perceived as legitimate, the research shows it must ensure that diversity is considered in nominating candidates and in appointing judges. A key recommendation is that states should focus on who has a voice in the selection process. I will now walk you through the bill now that you learned the background of how our judicial nominating board and process works, so you can follow along in today's calendar on page 514. Section 1 concerns the Judicial Nominating Board, which is the body expressly authorized by Section 32 of the Vermont Constitution to present judicial nominees to the governor. Section 36 of the Constitution authorizes the General Assembly to establish procedures for the board, which it has done and amended numerous times over the years. The first change in this bill is to change the Judicial Nominating Committee membership by adding one more member to serve on the commission. Section 1 of the bill expands the Judicial Nominating Board from its current 11 members to 12 members. Under current law, the 11 members of the JMB include 2 members appointed by the governor, 3 members elected by the House, 3 members elected by the Senate, and 3 members elected by the Vermont Bar Association. Section 1 of H80 adds a 12th member, the Executive Director of Racial Equity or his or her designee. Empirical research has illustrated that when decision-making bodies are more diverse, they recruit and recommend more diverse candidates. The second change is adding a nomination process in addition to self-nominations. Research has shown that women are much less likely than men to think that they are qualified for many jobs, including running for office. There is also extensive research that female candidates often won't consider running for office unless they've been asked to run. Does this hold true for women and other minorities for judicial application? We're not sure. What's the harm in trying it? Section 2 involves the procedures and criteria for judicial nominations. Currently, when a vacancy occurs, the Judicial Nominating Board notifies all attorneys in Vermont, and any member who is interested may apply. Section 2 establishes a process for a person to nominate another person to fill a vacancy. If a person is nominated, the court administrator is required to provide the person who was nominated with information about the application process so that person can decide whether to apply. The court administrator is also required to make a nomination form available on the judiciary's website. The third and fourth changes are related to the qualifications for applicants, which are also found in Section 2, where we look at residency requirements for judicial candidates. The bill makes no change to the requirement of 10 years of law practice experience. There is a change in the number of years of Vermont practice. Currently, candidates must be Vermont residents who have practiced law in Vermont for at least 10 years, with at least 5 of those 10 years of practice being immediately prior to the candidate's application. Subsection C of Section 2 maintains the requirement that candidates be Vermont residents who have practiced law for at least 10 years, but permits those 10 years of practice to be in other jurisdictions so long as the candidate practiced in Vermont for at least 3 years immediately prior to the candidate's application. And subsection C also maintains the board's authority to make exceptions to the requirement that the candidate's Vermont practice be contiguous and immediately preceding the candidate's application for reasons such as family, military, academic, or medical leave. The fourth change in the bill is that the bill adds 2 new requirements that the board must consider for each candidate. Currently, in evaluating candidates, board members use the criterion standards that are listed in subsection D of Section 2. Judicial candidates must have such qualities as integrity, legal knowledge and ability, judicial temperament, impartiality, communication capability, financial integrity, work ethic, administrative capability, courtroom experience, diligence, social consciousness, and public service. H780 adds 2 new requirements that the board must consider for each candidate. The first, subsection E, requires the board to consider the candidate's ties to the Vermont legal community and the candidate's familiarity with the Vermont legal system. And secondly, in subsection F, it requires the board to consider the extent to which a candidate would contribute to a judicial branch that has diverse backgrounds and a broad range of lived experience. The fifth change addresses a procedure issue that has not been clear and would be improved with clarity. Section 3 addresses how the Judicial Nominating Board should respond when a governor refuses to appoint anyone from the list of nominees submitted by the board and instead asks the board for a new list. This has occurred a number of times over the years under a number of different governors, and the JMB has generally agreed to the request and submitted an additional list to the governor. However, there have always been questions about whether requesting an additional list was constitutional, and if the JMB was permitted to give the governor a request of another list from the board, or if they should limit such request by providing that they are not able to do that. H780 would permit the governor to request an additional list from the board, but to limit such requests by providing that they may only be made once for each vacancy. After hearing different perspectives and consulting with legal counsel, or legislative counsel, the committee concluded that the approach should be deemed constitutional and is moving ahead with this interpretation. Section 32 of the Vermont Constitution governs the filling of judicial vacancies. The language of Section 32 provides, in pertinent part, that the governor, with the advice and consent of the Senate, shall fill a vacancy from a list of nominees presented by a judicial nominating board established by the General Assembly. In addition, Section 36 of the Constitution expressly grants the General Assembly the authority to establish procedures for the implementation of Section 32. It has been argued that the reference to a list in Section 32 permits the governor to ask for additional lists, since it is not limited to the list first submitted by the board. While this is plausible, and a plausible reading of it, after consulting with legislative counsel, the committee does not think it is the most persuasive reading. In fact, if this were the correct reading, the governor could continue asking for new lists indefinitely, which would directly contradict Section 32's command that the governor shall make a selection from a list provided by the board. The framers of the Constitution could not have intended that result. Rather, after consulting with legal counsel and the committee's view, we concluded that Section 32's language, the governor shall fill a vacancy from a list of nominees, sets out the process for filling a vacancy in a straightforward way. When there is a vacancy, the JMB submits a list of nominees to the governor, and the governor makes a selection from that list. Additionally, the General Assembly has the specific and express power to establish procedures to implement this process under Section 36. This language provides the legislature with the discretion and authority to permit the governor to ask the JMB for one additional list of nominees to fill a vacancy. The committee believes this is a constitutionally permissible approach to accommodating the joint authority that the governor and the legislature have with respect to judicial nominations and appointments. And finally, Section 4 provides that the bill takes effect on July 1st, 2024. Our committee heard from many witnesses, including the former attorney of the City of Burlington and former JMB member, the former Chief Administrative Judge and former JMB member, the Executive Director of the Office of Racial Equity, our Legislative Counsel many times, for which we're grateful, the former House member and former Chair of House Judiciary and former JMB member, the General Counsel from the Governor's Office, an attorney from Burlington and former JMB member, the Executive Director of the Vermont Bar Association, an attorney from Bennington and former JMB member, the current chair of the Judicial Nominating Board, who testified not in the capacity of the Judicial Nominating Board, but as an individual, and our current Chief Superior Judge for the Vermont Judiciary. The bill passed our committee by a vote of 10-1-0, and we urge this body's support. Thank you, Madam Speaker.
And now for the Committee on Appropriations, member from Underhill.
Thank you, Madam Speaker. Your House Appropriations Committee thanks House Judiciary for bringing us H780. H780 adds one more member to the Judicial Nominating Board. The new member is the Executive Director of Racial Equity, or designee. In the event any designee is eligible for a per diem, it will create a minimal financial impact. Your House Appropriations Committee made no changes to H780. Your House Appropriations Committee voted favorably 12-0-0 to approve H780 as amended by House Judiciary. We ask for the body's support. Thank you.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? Member from Georgia.
Thank you, Madam Speaker. I have a couple of questions. May I inquire of the presenter of the bill?
The member from Burlington is interrogated.
Madam Speaker, you have to forgive me. This is not my committee at all, and I'm not a lawyer, so this is all, in spite of my years here, this is all new to me. So I have a question. I refer you to page 515 in our calendar this morning, section 2. Let's see, it would be section 602 in the state law, sub A, sub 1, and then at the bottom of the page, C1. So this is one of the new sections this proposal would add, reducing the number of years of experience from 5 to 3. And it's got to be the 3 years immediately preceding the application. So it sounds to me like we're reducing the amount of experience these folks need to have. Is that correct? And if so, why?
Madam Speaker, yes and no. We still are requiring 10 years of law experience, and 3 out of those 10 years, as opposed to 5 out of those 10 years, are required to be in Vermont. There are many states that have no requirements for time spent doing legal work in that state, and this was a recommendation that came out of the task force on racial equity. We have talked to the Bar Association and others who felt that it would be fine to have, it would not compromise the quality of judges, but would actually be more in line with sort of middle of the road what other states are doing.
All right, so is the idea that if we reduce the number of years from 5 to 3, and I understand you said that we're not reducing the overall experience, that's good, but if we reduce that number of years, is the thinking that we'll be able to draw in more people from racially diverse backgrounds? Is that the plan?
It would not just racially diverse backgrounds. It would open up the application process to more people who have only practiced in Vermont for somewhere between, for any amount of years less than 5. And so if they were here for 4 years, they'd be eligible to apply. It doesn't mean that they will get the position. They will still go through a rigorous interview and reference checking process before we deem and vote on if they're highly qualified. And then it's up to the governor, who also very thoroughly vets his appointments. So it gets more people in the door to be considered.
Okay, I think I understand the reasoning. And I have another question too, Madam Speaker, if that's okay. I'm referring now over to page 517 in our calendar, sub E and sub F at the top third of the page, I guess. And I won't read these 2 sections aloud to you, but I'm wondering how we would determine such a thing as the candidate's ties to the Vermont legal community, familiarity, and the amount to which a candidate would contribute. It seems like that's looking forward into the future. How could we know that? How could we even estimate that to be a positive thing? Help me understand this, Madam Speaker, if you could.
Sure. So part of the process is getting references, and the JMB also checks with non-listed references. It's a confidential process, but there is a thorough sort of background check that occurs both at the JMB level and at the governor's office. If a candidate were not connected to the Vermont legal system, that would come out in the interviews and these talking to the listed and non-listed references. Again, the idea was making sure we were not compromising somebody's ability to be a successful judge, and they have 3 years of experience, but not every position, for example, might have a lot of interaction with other attorneys or the courts. And that was something that definitely is discussed when we meet with candidates. Also, they need to give us writing samples. There's a lot of questions that we get to ask them in our interviews, and that would really help us know how familiar they are with Vermont's legal system. As far as contributing to the judicial branch, the goal there is currently we have no authority to consider anything about a person's difference. Like, so if somebody is a BIPOC applicant, we can't consider that. And it may be that, as I talked about in the best practices, it's important that we have a judicial bench that reflects our population. We currently don't have that, and we currently have no mechanism to even consider those factors. This is not instead of meeting all the other criteria. This is in addition. Somebody might have been in a different kind of law practice. Diversity also is not somebody who's a public defender or a prosecutor. It could be somebody that works at legal aid or has been a law professor and practiced, or has done work in the nonprofit sector as an attorney. So it allows us to look at the individual, professional, and sort of personal experiences that people bring they would bring as part of themselves to performing the job. There are so many people that have had really interesting life experiences and jobs, and it's not something that currently is factored in at all.
I understand. Thank you, Madam Speaker.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Member from Poultney.
Madam Speaker, may I inquire of the presenter of the bill?
The member from Burlington is interrogated.
Thank you. I heard a few percentages, but I just want to be clear. What percentage of attorneys practicing in Vermont are women?
I do not have the number. I can tell you that 51% of the Vermont population is women. I don't have the number of I can get that for you, but I do not have that number. 41% of our current judges are women.
I didn't hear that last part.
Can you repeat that, member?
41% of our 37 judges are women.
Okay, correct. But I'm asking for the percent of attorneys practicing in Vermont that are women. Perhaps you can get that to me on third read.
I will do my best to do that, yes.
Similarly, what percent of attorneys practicing in Vermont are persons of color?
I am not sure if that information is available. I can certainly check with the bar, but I don't know if we don't collect data.
Okay, on third read, thank you. And historically, how many names are on a list that are given to our governor?
Madam Speaker, I can't speak to historically. I can speak to my experience since I've been on the JMB, and we recently had an unusual experience of only having 2 applicants apply for magistrate jobs. And so happily, both of them were deemed highly qualified. And so we sent 2 names up, and that's the lowest that I've seen. We have frequently sent up 10, 12 names. And since we have a number of applicants who apply more than once, we have also been able, in the last few years, to ask their permission if they were considered highly qualified within the last year, if we can send their name up again. So frequently that list will, even if we had 10 people we interviewed that Some of them were sent up as highly qualified. We've been able to add to that list by including the people interviewed within the past year that were highly qualified. And again, I don't have the exact numbers. I can see what it's been for the past. I can certainly see if I can reach the chair of the JMB and, give you those numbers, because we've been doing a lot of interviewing. There have been a lot of retirements and vacancies.
Okay, thank you. Thank you, member. My concern really is in the number of lists that are presented to the governor, and not knowing how many names are on that list. Whatever governor, my understanding is that the committee looked at not only the seated governor, but previous governors to this seated governor, and came up with 2 lists. And my concern is 2 lists, but is there 1 name on the list? Are there 100 names on the list? I think we need to be more clear in what a list actually is. And that is my concern with this bill at this particular moment. Thank you.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Member from Northfield.
Thank you, Madam Speaker. I did have a question for the presenter of the bill, but it actually got answered just a few moments ago. So I want to focus more on the specific meaning of some of the words used, and that's specific to the criteria F that's a consideration for a candidate in the middle of page 517. I think the term lived experience has come to acquire a specific meaning probably only in the past decade or 2. I'm familiar in one of the early uses of it, or what may have just seemed to me to be one of the earliest uses because it applied to my group, and that is individuals with lived experience of psychiatric disability or mental health challenges. And for a long time, that was just used as a reference, person with lived experience, and that's what it meant. And then it became clear, as it got used in other contexts, that one had to explain what the lived experience referred to. One of the evolving terms was a person with lived experience of the justice system, as a more appropriate reference than saying someone, for example, with a criminal history. But the bottom line, Madam Speaker, is that having a lived experience can't really stand alone, or it doesn't mean anything at all. It needs to be a lived experience of something. It relates to what kind of lived experience one has in order to have meaning. Otherwise, it's overly broad to the point of being not having a real point, and in fact, really injecting, I think, a lot of confusion when it's presented as a criteria. When the member explained or paraphrased it just a few moments ago, it was explained as meaning life experiences, the value of having a broad range of life experiences. And Madam Speaker, that may sound very similar to a range of lived experience, but I think lived experience really has become a very specific term of art, and that it probably would be more appropriate to talk about a broad range of life experiences as being something of value for candidates to bring to these positions. Thank you, Madam Speaker.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. Nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. One moment, members. All right, the final bill on our action calendar today is House Bill 847, which is an act relating to peer support provider and recovery support specialist certification. The bill was introduced by the Committee on Health Care. The member from Winooski, Representative Rebecca, will speak for the committee affecting the revenue of the state. The bill was referred to the Committee on Ways and Means, which recommends that the bill be amended as printed in today's calendar. The member from Westford, Representative Andrews, will speak for that committee. And then carrying an appropriation, the bill was referred to the Committee on Appropriations, which recommends that the bill ought to pass when amended as recommended by the Committee on Ways and Means. The member from Brattleboro, Representative Tolino, will speak for that committee. Please listen to the second reading of the bill.
H 847, an act relating to peer support provider and recovery support specialist certification.
Member from Winooski.
Madam Speaker, the history of peer support is older than the horsehair stuffed chairs that we sit on in this chamber. And so are the needs for support and understanding from people who have already been through it when you're navigating a mental health challenge or the waves of recovery. Most of the incremental solutions that we find to our broken healthcare system are technical, or they come with debatable costs or a long implementation tail. But this bill's different. H 847 can be found on the Healthcare Committee webpage, or I believe it was in Friday's calendar. So this bill formalizes the already established workforce in Vermont of qualified mental health support specialists and recovery coaches. And with the support of a credentialing entity, the Department of Mental Health and the Office of Professional Regulation, those professionals may take a standardized training and become certified in a manner that allows the state of Vermont to be reimbursed by the federal government, Medicaid, for their services. Results from the other 48 states, I'm going to repeat that, the other 48 states that have implemented peer certification legislation demonstrate that this will improve workforce efficiencies, patient outcomes, in addition to improving health equity and reducing our costs of healthcare. So what can that look like? Imagine having the right staff in the right place and us getting the healthcare that we need when we need it. It goes both ways though, because 60% of respondents in one study reported transitioning off of or reducing public assistance while they were working as certified peer workers. Okay, now for the fun part. Section 1 allows OPR to regulate peer support providers and recovery support specialists. Section 2 of the bill would require applicants for certification to pass criminal history and registry checks as described in the rule. And the bill would leave it up to the rulemaking process, and so in turn, the public and the stakeholders, to determine what level of criminal background check will be necessary for any applicants. So if stakeholders and the public decide the applicants should complete an FBI criminal background check to obtain peer support provider or recovery coach specialist certification, then Vermont already has in place the laws that authorize OPR to conduct that check. Now, Section 4 is our definitions. Those cover just simply what constitutes peer support and recovery support services. Just keep in mind that the definitions of these things are broad purposefully because we want to incorporate the many, many ways that peers and recovery support specialists provide these services to clients and patients in order to support their whole journeys. Section 4 also covers the duties of the director of OPR and the advisor appointees. The bill directs the appointment of 2 certified peer support providers, a representative from the Department of Mental Health, 2 recovery coach specialists, a representative from the Department of Health, and it also covers the eligibility in order to become certified. An individual has to be at least 18 years old. They have to obtain a credential from the peer support provider credentialing body, and they do have to have passed a criminal background, a criminal history and registry check as described in the rule, which will be developed. Lastly, this section covers unprofessional conduct, making clear that certified peer support providers and recovery support specialists are subject to any unprofessional conduct standards as already established in Title III, Section 129A. Section 5 simply requires OPR and the Department of Health and the Department of Mental Health to file initial rules for the implementation of this bill by September 1st of this year. Section 6 establishes that the bill will take effect on July 1st, 2025, with the exception of the effective date in Section 5, which is the rulemaking authority, that are going to take effect upon passage because we want this now. And Section 3A, which is the fees, will take effect on July 1st, 2027. And that simply allows folks to get into the field and begin to realize an income before the cost of certification, and that more closely pays the cost of regulating the profession. Madam Speaker, your Committee on Healthcare took testimony from the Office of Legislative Counsel, the Office of Professional Regulation in the Secretary of State's office, the Department of Mental Health, the Department of Health, Wilda White Consulting, Recovery Vermont, the Vermont Association for Mental Health and Addiction Recovery, the Executive Director of the Vermont Recovery Network, a recovery coach from Turning Point Center of Franklin County, a recovery coach from Turning Point Center of Addison County, a peer support provider from Pathways Vermont, the board vice president from Vermont Psychiatric Survivors, and we had a representative from the House Committee on Human Services. This bill has the potential to reduce the cost of healthcare. It also has the potential to improve access to appropriate care and jobs, and importantly, it supports what I like to call the modernization of our system of care by allowing us to deliver new models of integrated care that are evidence-based, Medicaid reimbursable, and they're person-centered. Vermont should extend compassion and support from every angle to our friends, our family, our colleagues, leaders, and neighbors who live with mental health and substance use challenges. We ought to recognize the expertise of those who have learned to navigate the pathways of recovery and professionalize their work because they've told us that they want that. So today, we have this act relating to peer support provider and recovery support specialist certification that allows us to all do better by them, lower our cost of care, and support our friends and family. The vote out of our committee was 11-0-0, and I ask you to support this bill.
And now speaking for the Committee on Ways and Means, member from Westford.
Madam Speaker, as we just learned from the member from Winooski, H 847, if passed, would provide a path for professional certification for peer support providers and recovery support specialists. You can find the bill on page 518 of today's calendar. This certification would provide professional regulation of these two professions and, importantly, would allow the institutions that employ them to bill Medicaid for their services. While the Ways and Means Committee appreciates the benefits of this bill, and I'm sure you've heard me say this before a few times, we also must acknowledge that the passage of H 847 would likely have a negative revenue impact on the state. You can find the fiscal note on the fiscal tab for this bill. While it is not known exactly how many peer support providers are currently practicing in the state, we do know that 169 are currently employed at designated agencies and peer-run entities across the state, and an additional 116 recovery support specialists are employed in Vermont. At the initial fee of $50 for certification, we estimate that $10,000 to $20,000 in fee revenue will be generated in fiscal 2026. We anticipate this amount to increase over time for two reasons. One is that these professions are expected to grow, and the second is that the fee is set to increase to $75 in 2027. However, we also anticipate that the Office of Professional Regulation and the Secretary of State's office will spend $25,000 to implement these new certifications. The bill also requires that the Office of Professional Regulation appoint 6 advisors, and we estimate that the additional cost of $2,000 for per diem charges for the non-state employee advisors. While the cost of implementing these certifications is likely to outweigh the revenue generated, your Ways and Means Committee appreciates that creating these certifications is good public policy. Ways and Means heard testimony from Director of Policy, Department of Mental Health, Deputy Secretary of State, Secretary of State's Office, Principal Fiscal Analyst, Joint Fiscal Office, General Counsel, Office of Professional Regulation, Secretary of State's Office, Legislative Counsel, Office of Legislative Counsel, Director of Substance Use Programs, Department of Health, and a consultant from Peer Workforce Development Initiative. Your Committee on Ways and Means feels that the benefits of this bill outweigh the revenue impact and therefore pass this bill out of committee favorably on a vote of 12-0-0. Your Committee on Ways and Means respectfully requests your support of this bill.
Member from Winooski.
Madam Speaker, the Committee on Healthcare heard the amendment and we voted 11-0-0 to support.
And now for the Committee on Appropriations, member from Brattleboro.
Madam Speaker, my presence here with you today to share the House Appropriations report might lead you to believe that this is another one of those compact bills, and you would be so close. As we heard from the bill report, this bill is a workforce bill, and it does utilize OPR to address licensure for peer support providers and recovery support specialists, though it is not a compact. Like the compacts, though, this bill has a fiscal impact on the OPR fund, and then unlike the compacts, we're not going to forego future revenue from licensure. The Ways and Means Amendment sets out those future fees. We had a walkthrough of the bill from Ledge Counsel and a review of the fiscal note from JFO. We consider the upside of this specialty workforce to be worth the cost to the OPR special fund, despite the ongoing concern of how we will bring the OPR fund back into balance. The committee vote was 12-0-0 in favor of the bill's passage.
The question is, shall the bill be amended as recommended by the Committee on Ways and Means? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? Member from Rutland City.
Thank you, Madam Speaker. I want to be clear, I'm in fully support of licensure to these important and vital services. As the bill is defined, peer supportive providers and recovery support specialists, there's a clear distinction between the two. And with that, recovery support specialists and recovery coaching is ingrained in substance use disorder. Substance use disorder is within the jurisdiction of the Human Services Committee. Therefore, Madam Speaker, at this time, I request that this bill is moved on over to the Human Services Committee for review.
The member from Rutland City moves that House Bill 847 be committed to the Committee on Human Services. Are you ready for that question? Member from Essex Junction.
Madam Speaker, thank you. As the member from Winooski indicated in her floor speech, we did hear from members of the recovery community as well as the Department of Health. We also had a member of the House Human Services Committee in our committee while we were taking testimony. And again, our vote was 11-0-0 in support of this bill. Thank you.
Member from Northfield.
Madam Speaker, I think we're all familiar with bills that actually have some overlapping jurisdiction among committees. And sometimes even we do what is colloquially termed a flyby, where the committee doesn't take possession, but takes a look at the parts that impact its jurisdiction. In this particular case, however, there are two really very distinct components to the bill. One has to do with peer support providers who, as defined, address mental health, peers in mental health recovery, specific to psychiatric and trauma issues, whereas recovery support specialists are very specifically defined as those who work on issues of substance use disorder. Madam Speaker, regardless of discussions in one committee, I believe that our public process and public access on an issue and regarding the hearing should, and actually is vitally, should be taking place within the committee of jurisdiction. I think process matters in something as substantive as this. And I support the motion and the appropriateness of the Human Services Committee looking at the component that is specific to its jurisdiction for substance use disorders.
The member from Lutton City moves that House Bill 847 be committed to the Committee on Human Services. Are you ready for that question? Member from Georgia.
Thanks, Madam Speaker. I agree that this bill ought to be sent over to the other committee as proposed. What we're doing here, at least our work on Ways and Means, gave this group of people a more formal, recognized status. And with that formality comes a process that I think we're looking at right here. So I encourage you to vote to send this on for further examination. Thanks.
The question is, shall Bill 847 be committed to the Committee on Human Services? Member from Brattleboro.
Madam Speaker, in addition to your House Healthcare Committee taking testimony from both divisions at the Agency of Human Services responsible for public health, substance use, and mental health, your Committee on Ways and Means also took testimony from all of those divisions. And I believe comprehensive testimony has been taken at this time, in addition to the significant work that stakeholders put in before this bill even came into our body. And I ask that we vote no on this motion.
The question is, shall House Bill 847 be committed to the Committee on Human Services? Member from Northfield.
Thank you, Madam Speaker. I'm rising in terms of the references to the extensive work of stakeholders. And as a past member of the Healthcare Committee, I'm well aware of the very extensive, longstanding work and efforts for peer certification. Madam Speaker, all of that work was targeted directly to mental health peer support. That was the direction, the testimony, and all of the background work. Recovery support specialists actually have a certification process currently, not through OPR, but have been active in that and have not been part of those discussions in the past. Madam Speaker, this was a committee bill, which was therefore not posted by its name, referencing substance use recovery specialists during its time of hearings and public notice. The addition of recovery support specialists was very late in the game. And although there was testimony taken by the Healthcare Committee, that is not the area of jurisdiction of the Healthcare Committee, and neither is it the area of jurisdiction of the Ways and Means Committee to hear testimony and assess not the financial or tax issues, but specifically the involvement and process of substance use disorder support. I urge the body to refer this for the appropriate consideration of the Human Services Committee in regard specifically to substance use disorder support peers where it fully needs to be vetted.
The question is, shall the bill be committed to the Committee on Human Services? Member from Essex Junction.
Madam Speaker, I appreciate the discussion around this really important bill. And oftentimes, we all have other people in our committees from another committee to ensure that there's collaboration on the work. We fully vetted this bill on all sides. All stakeholders are in agreement of this bill, and I strongly urge the body to vote no on this motion.
The question is, shall the bill be committed to the Committee on Human Services? Are you ready for the question?
Permission to speak a third time.
Absent objection, leave is granted.
I merely want to add, Madam Speaker, that at any time that I was sitting in my Human Services Committee, I never once heard any discussion or reference to the substance use disorder components of this bill.
The question is, shall the bill be committed to the Committee on Human Services? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. Nay. The nays appear to have it. The member from Georgia requests that the vote be taken by roll. Is the member sustained? The member is sustained. When the vote is taken, it will be taken by roll. The question, will the House please come to order? The question is, shall the bill be committed to the Committee on Human Services? Are you ready for the question? If so, member from Bennington.
Madam Speaker, I urge the body to vote no on this amendment. Again, I believe, as we've said in the past, there are often many times that there are committees of jurisdiction that overlap between, and we've heard time and time again that recovery centers and the community, basically the way that we think of peer support recovery specialists, the colloquial term is recovery coach. And we have heard time and time again within the Human Services Committee that this is a direction that they are moving for more than one reason. The main being that they know that it's the right thing to be able to bill Medicaid for their services. It's been a large part of the investments that we've been putting into this historically undervalued section of our substance use provider supports. Again, it's something that was a bit of a no-brainer for the recovery community as far as moving forward in this direction, finally getting the ability to receive certification privileges, really, to be recognized as professionals, not just volunteers, again, especially based on the value that they're bringing to our communities. And I would also just say that this bill does still provide for, well, I'll actually leave it there for this question. So again, I urge you to vote no on this motion to recommit it to the Committee on Human Services.
The question is, shall the bill be committed to the Committee on Human Services? Are you ready for the question? If so, will the clerk please call the roll?
Andrews of Westford.
2 minutes. Will the House please come to order and members kindly take their seats? I would like to remind members that we are in the middle of a roll call vote. Members and guests are prohibited from using computers, phones, or any type of electronic device. Please refrain from the passing of notes and conversation during a roll call. When the clerk calls your name, please answer in a loud and clear voice so the clerk can accurately record your vote. The question is, shall House Bill 847 be committed to the Committee on Human Services? Will the clerk please continue to call the roll?
Andriano of Orwell. Anthony of Berry City. No. Arison of Weathersfield. No. Arsenault of Williston. No. Austin of Colchester. No. Bartholomew of Heartland. No. Bartley of Fairfax. Beck of St. Johnsbury. No. Berbecco of Winooski. No. Byrong of Vergennes. No. Black of Essex. No. Bloomley of Burlington. No. Bongarts of Manchester. No. Boslin of Westminster. No. Boynan of Cambridge. No. Brady of Williston. No. Brannigan of Georgia. Yes. Brennan of Colchester. Brown of Richmond. No. Brownell of Pownell. Yes. Brumstead of Shelburne. No. Burdett of West Rutland. No. Burke of Brattleboro. No. Burrows of West Windsor. No. Buss of Woodstock. No. Campbell of St. Johnsbury. No. Canfield of Fairhaven. Yes. Carpenter of Hyde Park. Carroll of Bennington. Casey of Montpelier. No. Chapin of East Montpelier. Chase of Chester. No. Chase of Colchester. No. Chestnut Tangerman of Middletown Springs. Christie of Hartford. No. Sheena of Burlington. Clifford of Rutland City. Yes. Coffey of Guilford. No. Cole of Hartford. No. Conlon of Cornwall. No. Corcoran of Bennington. No. Cordes of Lincoln. Damar of Venusburg. Yes. Demrow of Corinth. No. Dickinson of St. Albans Town. Yes. Dodge of Essex. Dolan of Essex Junction. No. Dolan of Waitsfield. No. Donahue of Northfield. Yes. Durfee of Shaftesbury. No. Elder of Starksboro. Emmons of Springfield. No. Farley's Rubio of Barnet. No. Galfetti of Berrytown. Yes. Garifano of Essex. No. Goldman of Rockingham. No. Ghostland of Northfield. Graham of Williamstown. Yes. Granning of Jericho. Gregoire of Fairfield. Yes. Hengo of Berkshire. Yes. Harrison of Chittenden. Yes. Hedrick of Burlington. Yes. Higley of Lowell. Yes. Holcomb of Norwich. Yes. Hooper of Randolph. Hooper of Burlington. Houghton of Essex Junction. No. Howard of Rutland City. Hyman of South Burlington. No. James of Manchester. No. Jerome of Brandon. No. Kornheiser of Brattleboro. No. Krasnow of South Burlington. No. Labor of Morgan. Yes. LaBounty of Linden. Lally of Shelburne. No. Lalonde of South Burlington. No. Lamont of Morristown. Lanford, Virgins. LaRusha, Franklin. Levitt of Grand Isle. Lipsky of Stowe. Logan of Burlington. Long of Newfane. McGuire of Rutland City. Marcotte of Coventry. Maslin of Thetford. Matos of Milton. McCann of Montpelier. McCarthy of St. Albans City. McCoy of Pulteney. McFawn of Erie-Town. McGill of Bridport. Mahaly of Calais. Minier of South Burlington. Morgan of Milton. Morris of Springfield. Morrissey of Bennington. Rowicki of Putney. Mulvaney Stanek of Burlington. Nicole of Ludlow. Knott of Rutland City. Noyes of Wolcott. Nugent of South Burlington. O'Brien of Tunbridge. Odie of Burlington. Oliver of Sheldon. Page of Newport City. Payala of Londonderry. Parsons of Newberry. Pat of Worcester. Pearl of Danville. Pearl of Danville. Thank you. Peterson of Clarendon. Pouch of Heinsberg. Priestley of Bradford. Rachelson of Burlington. Rachelson of Burlington. Rice of Dorset. Roberts of Halifax. Samus of Castleton. Sakowitz of Randolph. Shai of Middlebury. Shaw of Pittsford. Sheldon of Middlebury. Sibilia of Dover. Sims of Craftsbury. Small of Winooski. Smith of Derby. Squirrel of Underhill. Stebbins of Burlington. Stevens of Waterbury. Stevens of Waterbury. Thank you. Stone of Burlington. Supernut of Barnard. Taylor of Milton. Taylor of Colchester. Templeman of Brownington. Tolino of Brattleboro. Toof of St. Albans Town. Torrey of Moortown. Triana of Stannard. Walker of Swanton. Waters Evans of Charlotte. White of Bethel. Women of Bennington. Williams of Berry City. Williams of Granby. Wilson of Linden. Wood of Waterbury. Andriano of Orwell. Burdett of West Rutland. Carol Bennington. Chapin of East Montpelier. Chestnut Tangerman of Middletown Springs. Gina of Burlington. Cordis of Lincoln. Dodge of Essex. Elder of Starksboro. Granning of Jericho. Hooper of Randolph. Howard of Rutland City. Lamont of Morristown. Lanford of Virgins. McCann of Montpelier. Samus of Castleton. Wilson of Linden. And Wood of Waterbury.
For purpose of explanation, member from Fairfax.
Thank you, Madam Speaker. While I am supportive of this legislation, I've said it before and I will continue to say it again, process matters.
Member from Winooski.
I'm voting no, Madam Speaker, because people with lived experience of mental health and substance use challenges and people representing the largest organized groups of those professionals have already asked the legislature to pass this. That's on public record, so I ask you to vote no.
And member from Northfield.
Madam Speaker, this vote is a slap in the face to the importance of transparency in our public processes of notice of subjects within a specific committee's explicit jurisdiction.
Member from Clarendon.
Madam Speaker, may I explain my vote?
You may.
The Healthcare Committee thoroughly reviewed this bill. However, when an expert in peer counseling has a suggestion, I give it my support. It will improve the bill.
Member from Fairfield.
Madam Speaker, may I explain my vote?
You may.
I strongly support this bill. However, process matters. There is zero harm in allowing the Human Services to look at this bill. There is, however, harm from circumventing process. As I always say, how we do things matter. And it matters every bit as much as the policies themselves.
Members, please listen to the results of your vote. Those voting yes, 39. Those voting no, 94. And you have declined to commit the bill to the Committee on Human Services. So now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Members, that completes the orders of the day. Are there any announcements? Will the House please come to order? Member from Brownington.
Thank you, Madam Speaker. Today we have in the building members from Vermont's 14 natural resource conservation districts. Conservation districts exist in every U.S. state and territory as they have a remarkable history, stemming from the Dust Bowl and continuing to today. You may remember learning about President Franklin Roosevelt's famous letter of 1937, in which FDR noted that the nation that destroys its soil destroys itself. One of the landmarks ways in which FDR responded to the Dust Bowl was by providing model legislation for each state to adopt and protect the nation's soil and natural resources, establishing soil conservation acts in every state across the country. He knew that conservation efforts had to be led and implemented at the local level. And this model legislation established county-level conservation districts to do just that. Please join me in welcoming our natural resource conservation districts to the People's House.
Will the guest of the member from Brownington please rise and be recognized? Are there any further announcements, member from Guilford?
Madam Speaker, February is Black History Month, and we are really so fortunate to have a really special group joining us tomorrow evening as part of Farmers Night. The group is A2VT, and we sent something out into your email inboxes, but just to give you a sense of who these Vermonters are, they're coming from several different countries in Africa, including Tanzania, Somalia, and they are bringing their African musical and dance roots combined with Western pop and hip hop sensibilities to share their music. And I think it's going to be a really special evening tomorrow. So please join us 7:30 here in the House chamber.
Are there any further announcements, member from Jericho?
Madam Speaker, in celebration of Public Schools Week, please join us for ice cream just outside of the State House over by the Thomas Chittenden statue at noon, so soon. We'll have something for everyone. We'll have dairy, we'll have non-dairy, we'll have chocolate, vanilla, and strawberry flavors. We also have some gluten and gluten-free flavors, both, just to provide the inclusivity that they have in public schools. So thank you, everyone. Please join us.
Are there any further announcements? Member from Newfane.
Madam Speaker, Democrats will caucus 10 minutes, not 15 minutes, 10 minutes after floor in the room 263 in the pavilion.
Member from Poultney.
Madam Speaker, House Republicans will caucus 10 minutes following adjournment in room 270 of the pavilion.
Member from Burlington.
Madam Speaker, House Progressives will caucus at 12:30 today in room 41, a little plot twist if you follow along with us. And we will be having guests to talk about our public transportation system in Vermont and changes to fares. And we have guests from the Green Mountain Transit and members of our own House Transportation Committee. All are welcome, 12:30.
Are there any further announcements? Member from Burlington.
Madam Speaker, today, members of the General Assembly, executive branch, and community members impacted by the Israeli-Gaza conflict will gather for a press conference at noon on the State House steps. We will present a letter addressed to President Joseph Biden that urges immediate action to demand a ceasefire to the Israeli government's military campaign in Gaza. All are welcome.
Are there any further announcements? Seeing none. Member from Poultney, can you please offer us a motion to adjourn until Wednesday, February 28th at 3 p.m.?
Madam Speaker, I make a motion this body stand in adjournment until Wednesday, February 28th, 2024 at 3 p.m.
You have heard the motion. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do